Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, we got some information that we're going to be delivering to you. And as we deliver this information, we want no one to misunderstand this. Okay, we don't want anyone to not get the picture. If you have family, if you have friends who are incarcerated or who have been incarcerated or who's going through anything with the system that they're trying to come at them for some negative stupidity, then you need to be having them pay attention to this video. Now, as you can hear in the background, we have Ready for the World, and they're asking no one to disturb this groove. So we're going to bring our volume down on our Ready for the World, and we're going to get to this video to get the information to you because it is important that you get this. There are two things that we are needing to bring to your attention. This information right here is one of those things. Sorry, that should not have been popping up. Let's go there. And I don't know what that is. Oh, World of Warship. That's a video game. Okay. As soon as my computer gives me control, what we need to do is 27 C period F period R period 7211. Many of you know what this is, but a lot of people don't know what it is, so don't spoil it for them. Okay? The first thing people want to do is speak on something before it's time. You don't know where we're going, so don't try to get there before us. Follow us. Don't try to figure out anything. Follow us. Okay, let's go to 2711. We're going to use Cornell Law because it's the official source of government law online. They'll tell you that they're the unofficial source, but no, sorry. Cornell University is the source that they use to put this up for you all publicly. Now we have meaning of terms. Now this is within the code. Now people say, well, that only applies to Title 27. No, it does not apply to Title 27. It applies to Title 27 and the meaning of commercial crimes. Let's do this. As used in this part, unless the context otherwise requires, the term shall have the meaning ascribed in this section. Words in the plural form shall include the singular and vice versa, and words importing the masculine gender shall include the feminine. The terms includes and including does not exclude things not enumerated, not included, which are of the same general class. That's the part you want to focus on. The term includes and excludes does not mean that it does not apply to the things that are similar that are not in this class or in this section. So let's go. We don't care about the ATF officer and what an ATF is and all of that stuff, ladies and gentlemen, because that's not the issue. We care about this right here. Commercial crimes. Any of the following types of crime, federal or state. Sorry, it went a little too far. Let me pause for just a quick second. Okay, ladies and gentlemen, pay attention. This is not me saying this. This is the law saying this. Commercial crimes, any of the following types of crime, federal or state. Doesn't matter if you have a federal or a state offense. Offense against revenue laws, that is the IRS people. Burglary, counterfeiting, forgery, kidnapping, larceny, robbery, illegal sales or possession of deadly weapons, prostitution, including solicitation, procuring, pandering, white slavery, keeping of ill fame, and like offenses, extortion, swindling or swindling, and confidence games or schemes, and attempting. This is the one you want to focus on. Everybody is accused of attempting to commit or conspiring to commit. These are the two. that everyone is always charged with. Go ahead and look at every indictment, every plea agreement. An individual pleads guilty for attempting to commit or conspiring to commit or compounding combination of any of the foregoing crimes. Addiction to narcotic drugs and the use of marijuana will be treated as if such crimes were commercial crimes. Pay attention. Will be treated as if it was a commercial crime. Now, you still don't know where we're going with this. So let's do this so that you guys will get it. My mouse is not giving me the ability. We got Teddy Pendergrass in the background. Ladies and gentlemen, he's talking about being left a certain way. It'll be just 1 second. It is the video card because I am using up resources doing the videos. I'll probably start using another video recorder, but for now, FAA. Uh-oh, I did it backwards. I already have all caps already on. Let's do you'll see it in a second. FAA stands for the Federal Arbitration Act. We're not concerned about the State Arbitration Act because once the Federal Arbitration Act has been invoked and placed into a contract, it supersedes any state arbitration acts. It is good that a person goes over the State Arbitration Act and its requirements, but the one you need to focus on, oh, yeah, I put inner as opposed to inter. Look, number 9, the FAA, Section 9 says unless the contract involves interstate commerce, watch this. Now, unless it involves interstate commerce, the FAA nor the federal common law of arbitration apply. Arbitration is a common law right, people. It says it right there in the Arbitration Act. Pay attention. Just got to go to FAA section number 9, but we're not going to go there just yet. We'll go there in a second. Now watch this. Hyphen. Ladies and gentlemen, interstate commerce is commercial. So that means that every case in every court is amendable to the Federal Arbitration Act, which means the process is applicable to every single case that's held in the court. Pay attention. Interstate commerce crimes, they're commercial crimes, people. Crimes committed, see, attempting to commit, conspiring to commit across state lines. A vast array of federal statutes are based on Congress's authority under the Commerce Clause, including the laws regarding drugs and firearms. Many federal crimes or criminal statutes expressly limit their application to acts that affect interstate commerce or that cross state lines. Pay attention. Many federal criminal statutes expressly limit their application because they cannot apply it to the private citizen. This is why Mr. Starks was a genius, because this is what they highlighted in their arbitration agreements, invoking their right to arbitrate. I didn't see it at first. I'm sitting up here this morning having a conversation with my God, and I'm going over some things in my head while I'm laying in my bed having that conversation with him, and this point came to me. Ladies and gentlemen, you talk about a game changer. That's why I told you this will change the entire game from this point on. Now let's talk about it, okay? We're going to do it this way so that you all get it. What is it? 9 U SC, and I said number 9, but it's not that. It's actually, we're going to go to number 1 first. Now, you're going to see when we get here that, again, remember, this is contract law. So the first thing we want to do is go here. The late Dennis Edwards, ladies and gentlemen. See, international commercial arbitration. That was the reason why they did this, ladies and gentlemen, because they needed to gain control. So what we wanted, see, commerce defined. Let's find out what the Arbitration Act defines as commerce. We're going to bring this a little bit bigger this way as opposed to me enlarging the screen. Don't look any further, ladies and gentlemen. This is the information. This is why Congress said the contract was valid and binding, and why the arbitration was valid and binding. Stop. What you need? If it'd just let me do what I need to do. Come on now. Oh, that ain't the one? Oh, that's right. This is Opera. I'm sorry, ladies and gentlemen. With Opera, I have to do it over here. I don't use Opera too often because I've had too many problems with Opera. And, I don't like going to them things. There's just too many pompous people there at the opera. Okay, it's not going to let me. Let's pause you guys for a second. Okay, two birds, one stone. Let's read section number 1 of the Arbitration Act to let you know that the State Arbitration Act does not apply. Maritime transactions, yes, that's right, we know the courts operate in admiralty as well, as herein defined, means charter parties. That is, pay attention, all of those government agencies, bills of lading for water carriers, agreements relating to wharfage, supplies furnished vessels, or repairs to vessels, collisions, or any other matter in foreign commerce, which, if the subject of the controversy, would be embraced within admiralty jurisdiction. Commerce, as herein defined, means commerce among the several states, or with foreign nations, or in any territory of the United States, or in the District of Columbia, or between any such territories and another, that's you, or between any such territory or any state or foreign nation, between the District of Columbia or any state or territory or foreign nation. But nothing herein contained shall apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. You are not a class of worker. You are a private citizen. So the last part doesn't apply to you. See, when Congress did this, they wanted to make sure that the government employees can't sue through arbitration. But arbitration is a lawsuit, people, and if you don't understand that, you need to go back and understand what a lawsuit is. It's a suit against one party by another party for infringement or breach of an agreement. This is Leela James, ladies and gentlemen, and she's doing the song that was done by No Doubt, Don't Speak. This is the information they don't want you to get. That's why I'm delivering it to you. Now, let me show you how powerful arbitration is. If you want to visit this site, just go here, just type this in, Arbitration Nation, okay? The actual site is arbitrationnation.com. I've not been to this site before. Well, I've had it on my computer, but I just never went here to read it because I was doing severability doctrine, sends two disputes to arbitration. Let's find out how this occurred. I might have to put y'all on pause because I got to answer this. 1 second, ladies and gentlemen. This is the gentleman who I've known since 2006, and I promised him if ever he called, I'll answer. Okay, ladies and gentlemen, that particular gentleman who called me, his name is Kenneth. And Kenneth, I met while I was in New York. He was the first person I met in New York. And I told him, I'm new here, don't know anybody. You seem like you're an all right person. And I gave him my number. And it took him a year. And he called me. And I told him, I said, Ken, if you had called me, because he says, you know who this is? I said, yeah, I know exactly who this is. And I said, but if you had called me a year ago, you would have been my best friend. And as of this time, right now, he is the one person that I've known the longest that I still communicate with. And so I made a promise to him a couple of years ago, because we've kept in touch with each other, that if he called, I would make time for him. So that's why I had to do that. Just thought I'd explain that. Now, since it's all ending, let me go ahead and finish this video if you guys don't mind. Let's finish talking about this. This is a company where they're talking about arbitration. Now, some people have been asking, how do you enforce it? How do you do this? How do you do that? Does it work? And look, here, I don't really appreciate those people. Okay, people say, but those are legitimate questions. They may be legitimate questions. But let me explain to you. As we told you, Congress is actively trying to stop you from utilizing this process. It wasn't until this morning that I realized why they are trying to stop it, because all of their acts include commerce. As you just saw, Congress gets its powers from the Commerce Clause. Ladies and gentlemen, look at how many times commerce appears. You got commerce there, you got commerce here, you got commerce here. Do you understand? This is all about commerce. Okay? That's why Congress introduced this junk. So, as long as it involves commerce, commerce is Congress, it's not your state, it's Congress. Foreign or interstate commerce between the states or within the state. Pay attention. Between the states or within the states or foreign commerce, it becomes Congress's right to regulate. That's why it doesn't matter if it's state or federal. Any state or the United States, it doesn't matter if it's federal or the state. If you remember, we showed you earlier that a commercial crime is any crime, federal or state, that involves blah, blah, blah. Do you understand? Leela does. Tell him, Leela. She says, don't tell him. Don't tell her because it hurts, y'all. All right. One of the most confounding doctrines in federal arbitration jurisprudence is the severability doctrine. What's the severability doctrine? Well, let her explain. The United States Supreme Court held in Paint, in 1967, that the courts must pay attention, that the courts must enforce arbitration clauses within contracts, even if the entire contract is invalid and unenforceable. Why? Because only the arbitrator can determine whether the contract is invalid or unenforceable. Most non-binding or non-arbitration geeks don't believe me when I tell them that that is the law. Uh-oh, interesting, ain't it? The only time, and I didn't write this, people. My phone's about to ring again. Okay, no, it stopped. All right. The only time a court can address the argument of invalidity or invalidity is if the litigant directs it specifically at the arbitration clause. For example, an argument that the elves contract with Santa is invalid because it Santa elves, she did this on December 2018. Okay, And I can only suggest that this was done as a result of the videos. Let me explain. We've been putting up videos for more than 3 months, and Mrs. Liz Kramer on December 18th, 2018, posted the validity of arbitration agreements, waiver of rights to arbitrate. Okay? I can only believe that such was done as a result of the increased conversations on arbitration. So let's say the elves said their contract with Santa was invalid because it's illegal to pay them, and candy canes is an argument about the contract as a whole and would get sent to arbitration if the elves contract had a valid arbitration clause. On the other hand, and that's why the arbitration clause has to include certain things, valid arbitration. On the other hand, an argument that the arbitration clause in the elves contract with Santa is unconscionable because it calls for arbitration in the South Pole with Mrs. Claus as the arbitrator is specific to the arbitration clause and should be decided by the court. That's correct. Unless, of course, the arbitration clause clearly and unmistakably delegates the questions of validity to an arbitrator, which is what ours does. So let's talk about some other cases. We got to go back down. Sorry about that. How did I get this? Give me a second. Gotta get the page to reformat. Oh, by the way, in the background is Tevin Campbell. He's singing a song from the album. I believe it was just simply called Tevin. No, I don't think this one was called Tevin. Dag nabbit. And that's because I spoke on it, so now I have to explain it. So, this is Don't Throw Your Life Away. And yeah, it is from the album. The album Tevin. But anyway, two courts recently had an opportunity to remind litigants of the severability doctrine in Rogers versus Sweepy. Sweepy. Oh, Sweepy was such a good character. The Sixth Circuit decided December 10th, 2018. The Sixth Circuit reversed a district court judge who failed to apply the severability doctrine. In Rogers, the putative class of landowners brought, and this is a class, ladies and gentlemen, brought suit against Shell for claims arising out of lease agreements. Shell responded by moving to compel arbitration. Ladies and gentlemen, we just did a motion on a motion to compel arbitration. This is the process. So those of you who don't know nothing about nothing, who want to question this man, you need to shut it up. I don't care if you don't like me. You cannot refute the information that I'm putting out, especially those of you who don't know anything about law. Now, I definitely demand that everybody do their research, but don't sit up here and challenge me when you don't know what you're talking about. I've been doing this for way too long. I've already told most of you, and we've already, how did I lose that? That was my opera. I got to get opera to come back up. Hold on one second. Well, no, we're going to talk to you guys while it's pulling up. We've already had conversations. That's the reason why I don't use opera. It's glitchy. And so, but I have it on my computer, but I have one browser, two browser, three browser, four browser, five browser, six browsers. Then we're not even going to talk about Chrome and Internet Explorer and Edge. Those are three more browsers. Okay, so that's 9 browsers on my computer. Why do you need 9 browsers? Because if you can see, I'm constantly all over the place with research. So each browser is situated and set up for different things. Okay, this is Luther, ladies and gentlemen. Y'all know Luther. He's talking about how he doesn't want to be a fool anymore. So many of you have been fooled by the system. You go through these criminal cases and they put you through these criminal so-called processes when you don't realize that it's a civil process. It's not a criminal process. All crimes are commercial. If all crimes are commercial, that means it's a civil process. It is not a criminal process. There is no such thing as a commercial crime. They invented that. That's why they have their own definition for it. See, the fact that they have their own definition indicates that they invented it. But nobody wants to pay attention to this. It's their creation. That's why they can set the definition for it. It really is that simple. So, if you don't want to be that fool, then my suggestion is that you sit up here and take in the information and learn from the information. Now I'm going to pause y'all for a second. Okay, ladies and gentlemen, it says the landowners argued that the arbitration clause within the lease agreement, as well as the whole second phase of the lease, was only triggered upon payment of a bonus. The court found this was an attack on more than just the arbitration clause, and therefore application of the severability doctrine called for the issue to be arbitrability to be decided by an arbitrator. That's our situation, ladies and gentlemen. Our contracts require the same thing. However, whether class arbitration is permissible should be decided by the court on remand. Look, ladies and gentlemen, they're saying if a class can do arbitration, of course a class can do arbitration. It's a common law right. Okay, but anyway, let's continue. Similarly, the Supreme Court of Montana sent the dispute over the arbitrability to an arbitrator in Peeler versus Rocky Mountain Log Homes, Canada. Okay, in Peeler, an owner sued both the design professional and the contractor over claims related to construction of a custom log home. Only the contractor agreement had an arbitration clause, but the complaint alleged design firm was an affiliated entity and that should be treated the same as the contractor, which is true. So the contractor and the design firm moved to compel arbitration. The homeowner argued that the arbitration agreement was permissive and not mandatory, and that the defendant had waived the right to arbitrate by waiting to assert it until after he filed the lawsuit. Not true. Okay, these arguments did not prevail at the trial court or at the appellate court. Why? Because it has an arbitration clause. It is not when one decides to enforce the arbitration clause or assert the arbitration clause. The law says the fact that it has an arbitration clause is the issue. It was their attorney who said that other junk right there, and that's why that did not work. The Montana Supreme Court noted that the defendant did not waive their right to arbitrate, and because the owner did not challenge the validity or the enforceability of the arbitration agreement, his argument should be heard by an arbitrator, which is true with exactly what I just said. Again, I know what I'm talking about because I understand the fundamental principles behind how they create these stupid laws in the first place. Finally, the court found that the design firm could compel arbitration as a matter of equitable estoppel. Okay? That's right. They were stopped from going anyplace else because the arbitration clause said that that was the exclusive remedy and means for handling that dispute. So, equitable estoppel. Now you're going to see the Supreme Court of Nevada. That was the document that we used, and this is the case that it's going to talk about. I don't even have to go to the Lanier case to tell you that that's what they were going to talk about, because that's the exact case we used and all the case law in that case. All right. Speaking of the construction cases, the Supreme Court of Nevada continues its campaign to remind all construction litigators that the Federal Arbitration Act governs even local dispute between homeowners and contractors. Since the Ballesteros decision, that's an interesting name, ain't it? In February this year, it has issued two more decisions reiterating the holding. Lanier 2018 and the Greystone 2018 as evidence of interstate commerce. Pay attention. Okay, I did not write this. Evidence of interstate commerce. Those of you who have people who are in jail, take a look at the plea agreement. It specifically uses the word interstate commerce at least 4 times. Every single charge contains interstate commerce, and then after the charge, then there's another issue of interstate commerce where the individual agrees to have affected interstate commerce, which is why you can do a change in terms of agreement. Okay? Lanier points out 3 things: that the builder was incorporated in Delaware while the homeowners were in Nevada residents. The large number of subcontractors and material supply. Wait, folks, hold on a second. It doesn't matter where you're located because the FAA governs suits in. Hold on. There are people who challenge what I know, whether I know what I'm talking about, whether I know what I'm doing. So let me tell you something that I know automatically. Sorry, this wasn't already pulled up because I had to restart this whole thing. Okay, so this wasn't automatically already pulled up. Come on now. Transactions defined interstate commerce. So while I'm doing that, pay attention. The United States and the District of Columbia, or between any such territory, foreign nation. Okay, it covers everything. The Arbitration Act is not for just one state. So let's see what their, let's bring that down. So if I have to come back here again, let's see if their argument can hold water. All right. It says that they were incorporated in 2 different locations, and a large number of the subcontractors and the material suppliers who worked on the homes made it likely that at least some of them were engaged in interstate commerce. And in the aggregate, the general practice of developing, buying, and selling homes substantially affects interstate commerce, which brings into the FAA, brings that in application. All of this mattered because the trial court judge were relying on the Nevada arbitration rules and refused to compel arbitration. Nevada arbitration rules do not apply when interstate commerce is involved, which is why we pointed out to you in our document that we kept highlighting that it involved commerce. Those rules are preempted, preceded, put in the background if a dispute is governed by the FAA. And we just showed you that it's governed by the FAA. So let's go up. Oh, by the way, ladies and gentlemen, we were doing a video yesterday and we talked about the fact that so many people have done certain songs. This is the great Donny Hathaway, and he's singing a song for you. And you've heard Whitney Houston has done a version of this, Ray Charles has done a version of this, and even Usher has done a version of this song. It's called A Song for You. I've loved it since I heard it for the first time. All right. In the Beckerstaff versus SunTrust Bank, the issue was whether a class action challenging overdraft fees could proceed in court. The class complaint was filed in July of 2010, and in August of 2010, in response to a court ruling, the bank amended its deposit agreement and allowed customers to opt out of arbitration. In part, the amended arbitration agreement stated, hold on, to reject this arbitration agreement provision, you must send the bank a written notice of your decision by the latter of October 1st, 2010, or within 45 days of the opening of your account. Such notice must include a statement that you wish to reject the arbitration agreement, along with your name, name, account number, and your signature. This is the sole and only method by which you may reject arbitration provision. Okay? Now, they said because the court said that they had to include an arbitration rejection provision. Okay, an arbitration opt-out position or waiver. Dream Merchant, ladies and gentlemen, New Birth. Just after October 1st, the bank moved to compel to compel arbitration. The issue of whether the complaint could serve as a formal rejection of the arbitration provision ended up before the Supreme Court of Georgia. But look, they had to do it before October 1st. So when they responded, if it wasn't before October 1st, and by the way, they had to follow the arbitration agreement. Pay attention. That's the reason why this person quoted this from the actual case, because I promise you the Supreme Court relied on this, and I have not read this yet, but pay attention. This is the sole and only method by which you can reject this arbitration agreement. Okay? So a lawyer would come up and say, well, the rejection would be the fact that they filed the lawsuit and they did a response to it. Nope, not it. Okay. The court unanimously held that filing the Bickerstaff complaint, thereby signaling his rejection of the arbitration agreement, told the time to which punitive class members were required to notify SunTrust of their intent to reject the arbitration. Ladies and gentlemen, that is a lie, because the Supreme Court had to go by the agreement. So if they take that, and that's the Supreme Court of Georgia, if they take it and appeal it to federal court, they will find that it will be overturned, because, and this was just done, so hopefully their attorneys will pay attention to this. The arbitration agreement specifically stated that that would be the sole and only way to reject the arbitration agreement. Not filing a response to a complaint filed in court. No, no, that's not your rejecting. Okay, now hold on. Let me make sure, because I believe this is where the Supreme Court of Georgia relied upon. Let me show you where the Supreme Court of Georgia, and so they're going to have to get past this aspect of it. It says, send a notice to include a statement that you wish to reject the arbitration agreement. They would have to have a statement that is unambiguous saying that they wish to reject the arbitration agreement. The complaint response includes their name, it includes their address, it includes the account name, it includes the account number, and it includes their signature. So this is probably what the Supreme Court is relying on. And the banks were served a copy of the response. So yes, the attorney was pretty bright. I give him credit, because when he filed his response and went into court, this was his showing their formal rejection. So it did toll the statute or the arbitration clause. So I give them their credit for that. Oh, by the way, the Dow Jones is down 300 points. I'm not surprised. I told you that this is the way things were going to go with that. Now, just after this thing, in its analysis, the court leaned heavily on Georgia cases in a class action context, finding that class representatives may satisfy statutory or contractual preconditions on behalf of those class members who remain in the class after it is certified. The satisfaction of preconditions for a suit by a class plaintiff typically avoids the necessity of each class member to satisfy the preconditions individually. Curiously absent from the decision was any decision in the Nielsen or Section 2 of the FAA requiring strict enforcement of valid arbitration agreements and the preemption ruling in Conception versus DirecTV. They didn't have to do that, ladies and gentlemen. Okay? They did not have to do that. The reason why they didn't have to do that is because the act only required they send in the information, and they did send it in their response. So the court was 100% accurate, and the attorney who had that case, I give him credit for coming up with that. Split South Carolina court reasons its way around Rent-A-Center. In the next state court ruling, at least acknowledges relevant federal precedent. In this case, the issue was whether a husband and wife had to arbitrate their construction defect claim against their builder. Section 14 of the parties' agreement was entitled Warranties and Dispute Resolution and made up of 10 subparagraphs covering topics from whether the builder could remove existing trees and private warranty it provided to the requirements to arbitrate dispute. I got it. This is a SATCOM member. We'll get back to this in just a second. Okay, ladies and gentlemen, like I said, SATCOM call, had to take that call. But now, again, The agreement, the arbitration agreement, was in 14, section 14 of the agreement, with its own subheading, mandatory binding arbitration. So the arbitration clause was unambiguous. It wasn't just in the middle of the document. Okay, it wasn't just in the middle of the wording where it was obscured. No, mandatory binding arbitration. If you look at our document, the arbitration clause is highlighted. As a matter of fact, nah, we'll keep this. The builders moved to compel arbitration, and the homeowners argued that the clause within 14 made the arbitration agreement unconscionable. Well, that's one of the issues you have to raise, is that it's unconscionable, okay, or it doesn't exist at all. The builders relied on the severability doctrine. First set forth the prima paint, but reiterated the Buckeye check cashing and arena center cases, which holds that the courts may only decide disputes about the validity of an arbitration agreement itself. All other challenges to the contract must be determined by the arbitrator. The builders define the arbitration agreement in 4 section of that document, 4 and in 14G, that's the arbitration section, which the homeowners did not challenge, while the homeowners defined the arbitration agreement as all of section 14. And that's right, that means they're challenging 14G as well. The courts agreed with the homeowners, relying largely on the title of section 14, and the facts of subparagraphs had cross-referenced one another, intertwining the subparagraphs so as to constitute a single provision. Yes, it is a single provision. It's section 14. That's a subsection. You can challenge the whole provision. Anyway, having defined the arbitration agreement to include all of section 14, the court went on to find the arbitration agreement as unconscionable due to its disclaiming implied warranty claims and prohibited monetary damages. Yeah, because you should be allowed to get monetary damages. As section 14 had no severability clause, the court refused to analyze whether the unconscionable portion could be stricken. 2 justices dissented, noting that the majority has not followed controlling precedent of the Supreme Court, and that should help with the certiorari petition. Yeah, petitioning the Supreme Court for certiorari. Look, ladies and gentlemen, please understand, this case will be overturned. Why? Because the arbitration section, this was not a class action. The arbitration section can only be determined not by the courts, but by the arbitrator. That is the Federal Arbitration Act. And because this involved interstate commerce, okay, it must only be decided by the arbitrator. Note to drafters, move your arbitration agreement into a separate paragraph with its own heading right now. Give it its own severability clause. No, I'm not doing no severability. Yeah, it already has a severability clause. Then you can keep on reading. Oh no, I can't keep reading? Okay, North Dakota forgets to read the footnotes. Not to be left out is the Buck SCOTUS. This is the Supreme Court of the United States. That's what SCOTUS means, Supreme Court of the United States. Summer trend. North Dakota issued a decision finding that the district court did not err in compelling arbitration of the formation of parties contract. 26th Street Hospitality LLP, Real Builders Incorporated. One party to the contract argued that the contract was invalid because it was executed without the knowledge and authority of the partnership, as proper consent had not been received pursuant to the company's chartered documents. Nevertheless, the district court compelled the arbitration without deciding the formation of the contract because it could not. It's an arbitration issue. The North Dakota Supreme Court unanimously found that the district court did not err, which is a district county court, ladies and gentlemen, not a district federal court, but a district county court. Okay, ladies and gentlemen, this is our Hotel California in my background. You can't hear it, but you'll be able to hear it just a little bit faintly in the background. This is the original song, okay, by them beginners. Think their names is Genesis. Y'all know them? I mean the Eagles. I said Genesis. Sorry. Yeah, that good old Dow Jones market plunging 300 points. I just did a video yesterday telling people the Dow doesn't work that way. It doesn't go up 200 points the next day down 300 points. And that's exactly what it's done the last 3 sessions. Up and down, up and down, up and down. Hundreds of points. The Dow Jones doesn't work that way, ladies and gentlemen. But it's okay. We'll talk about that in a different video. Now, what it did not discuss, however, is the first footnote in Buckeye check cashing, which specifically states that the severability doctrine does not apply when the issue is whether any agreement between the alleged obligator and the obligee was ever concluded. Okay? And the fact that the majority of federal courts have concluded the formation is an issue for the courts, not the arbitrator. It doesn't matter what they've concluded, it matters what the Supreme Court concludes. And if that was being decided, that particular case was being decided on the Dakota case was being decided on a state level, they don't have to go by the federal. Okay, they can go by their own state arbitration as long as it doesn't conflict with the FAA. Now, as long as we're talking about state courts, see, talking about state courts. The 2 state Supreme Courts have new decisions on waivers. The Texas Supreme Court found a company did not waive its rights to arbitration claim with individual consumers in RSL Funding Incorporated and Pippins, Scotty. Sorry, it's not Scotty, Pippins anyway. Importantly, the Texas court said that for Party A to waive its rights to arbitrate with Party B, the court will only analyze Party A's litigation conduct with respects to Party B after the dispute arises. In this case, the majority of the company's litigators' conduct at issue was directed at third parties before a dispute arose with the individual customers. Okay. With our own device in the master's chambers. Okay, anyway, the Supreme Court of South Carolina found a nursing home waived its rights to arbitrate wrongful death claims in Johnson versus Heritage Healthcare. The nursing home had litigated over the estate rights to records and conducted discovery before moving to compel arbitration. I don't know this, so let's read this. It's Arbitration Nation. Uh-oh, it happened again. 1 second. Ladies and gentlemen, this is the next article, but okay, what's happening is this is 2016. So these are other cases from 2016 that was what went on afterwards. Now, what I'm believing, I want you to understand something, that the issue that they're bringing up here, I would use these cases and the decisions of these courts in your case. For instance, I know that many of you are not going to get this, so what I'm going to do is I'm going to do the best I can to highlight it to you so that you get it. Because, again, some of you, it's going to be difficult for you to grasp. We're going here, and that's right, I forgot to tell you, you just saw I had to restart this, but I didn't open this page, so it will take a second for this page to log on. This is Cornell Law, and there you go. We're programmed to receive. You can check out anytime you like, but you can never leave. Isn't that what the system told you? That once you're part of the system, you remain part of the system? When we told you that this was the way out of the system, this was the way to get access by contracting with them and arbitrating whether or not you have the right to the funds held in your minor account, that if somebody placed you in a confinement situation where it did not involve the injury to another party, that you could arbitrate your way out, because arbitration includes all items that involve commerce. Go take a look at your crime that you were alleged to have committed and see if it's not defined as involving commerce. And even if you don't think that it's defined as involving commerce, the contract, I clicked on the wrong thing. Got to go here. Okay, what I'm trying to do is click here. Come. Sorry, I like this song, Hotel California. And this part right here. Hey, even though this is the end of the song, there are no more words. This group, the Eagles, did a very good job with this song. That's why, to this day, this song gets recognition by everybody. They can't wait but to hear this song when it's played. Okay, pay attention. Commercial crimes across state lines. A vast array of federal statutes are based on Congress's authority under the Commerce Clause, including laws regarding drugs and firearms. Many federal crime statutes expressly limit their application to acts that affect interstate commerce and cross state lines. So, how do we determine what those limits are? Hold on. This right here is Color Me Bad. This is called the Earth, the Moon, and the Sun. Okay, I added the Earth, the Moon, the Sun. And I've always liked this song. This is from the album that they did when they first came out in New Jack City. When I was lost, I could not see all the beauty and wonder that was around me. I was alone, waiting. I thought I was going to say waiting, but it is dreaming of you. This dream coming true. Oh, much to wonder. See, Color Me Bad. Y'all thought all they could do was talk about sexing something up, huh? I will love you for the earth at my feet. I will love you for the sun in the sky. I will love you for the falling rain. Oh, I will love you for the heart that could break. I gotta pause y'all, ladies and gentlemen, because it's the video card. 1 second. Ladies and gentlemen, this is what I wanted to show you, because this is very important, because some of you are not going to get it. See, when I tell you you can't do something, many people, no, I'm going to do it anyway. Okay, knock yourselves out, because those are the people I'm not talking to. I'm not talking about the crackheads, the ones who are just going to do things because they feel like it, because they convince themselves they can do something. So let me go ahead and do what I do best. I'm going to explain the law to you, because ignorance is your excuse. Ladies and gentlemen, commercial crimes, ignorance is the excuse for those stupid people. That's right, I said it. Stupid people are those who don't know how to listen. You don't believe me? Go and look at the definition. A stupid person doesn't listen. Commercial crimes. Any of the following types of crimes, whether federal or state, any includes all and excludes none. Any of the following types of crimes, types. It didn't say any of the following crimes, it says types of crimes. Okay, I want you to do me a favor, those of you who are intelligent, not those who you think you're intelligent, but those who are intelligent. Nobody can tell you whether you're intelligent or not. You know whether you're intelligent or not. Trust me. That's not something somebody can walk up and pat you on the back. Hey, you're intelligent. Okay? You know whether you're intelligent or not. You don't need somebody to tell you you're intelligent, nor do you have to prove that to yourself. Give me a second. It's not responding. Those of you, let me go ahead and pause this for a second. Okay. Ladies and gentlemen, do you see this right here? Do you see where it speaks about commercial crimes? Go in here and see if you can find one crime here that's listed that involves the harming of another person. Kidnapping, no. Kidnapping is just the taking of someone against their will, but it does not involve any type of an assault. Go ahead, take a look. See if you see any crime listed that involves the harming of another person, the violation of common law. You don't, do you? So the contracts are designed this way, the same as Congress did it, under the principle as harming another person is a crime. It is not a commercial crime. It is a violation of common law. It is a crime. Okay, and there is no saving you through the administrative process for such a crime, unless you can prove you didn't do it. But then again, these contracts are not designed that way. So you cannot use these contracts for such because we didn't write them for that. Okay. Yeah, we're gonna let this is George Michaels, ladies and gentlemen. We're gonna let him play in the background, but please understand you cannot use this for crimes involving the assault of another person. Yes, I know nobody has ever brought this to your attention because I don't pretend to know law, ladies and gentlemen. I pretend to say that I'm stupid. Okay, I'll pretend to say that. But I'm going to let you know something right here. I've been doing this law thing for a while now, studying how they put the words together, why they use certain words, which word means what, why it means this, and how the statements mean this. That's why I can go over cases like the ones we went over earlier to be able to tell you exactly what the court's decision was based on, why they decided this, based on what principle. Once you understand the principles of law, then you can read law and understand law. So we told all of you the basic fundamental principles of statutory interpretation is what you must understand. Because those, but I just need to know maxims. No, because if you don't know the principles of statutory interpretation, how are you going to understand a maxim? Just quoting a maxim is not enough. You have to know when that maxim applies and when it doesn't apply. That's what the courts are doing. But how come some courts make some decisions that ain't according to the maxim or the law? Well, oh, and by the way, when you see the arbitration, none of it involves the harming of another person. Okay? Just really that simple. You just need to understand. So once you understand this, those of you who have cases, let's talk. Hey, George, we're going to have to put you on pause because we got to talk to people because we're about to conclude this video. Ladies and gentlemen, we cut everything off. We're going to keep this. I'm going to explain this in less than 2 minutes so that you guys will get it because we're going to bring this to under an hour long. If you have a case, had a case, you do the contract, the incarceration contract. The reason why you do that is because it involved your case, interstate commerce. The contract is already written, already has the challenges in the contract. You only just need to add a little bit of history and the facts and the case number and all that if you want. Other than that, you just fill in the information that you need to fill in. You have somebody who's in jail, send him a copy, tell him to have his friends, have their family members download a copy and fill out for them. And then you send it out to the Attorney General. Here's the thing, and I don't care if they know. It doesn't matter if they know because they handle thousands of cases a month. They have thousands of employees. I don't care about no government shutdown. That does not excuse them for not responding to the contract. If they received 100,000 contracts in a month and the contract explicitly gives them a certain specific time to respond, and they respond with one of those general responses and do not respond according to the terms of the contract, they are in default and have acquiesced and agreed to all of the terms of our contract. That's the reason it's written that way. The same as if you don't respond to the court within a certain period of time, and how many days do they give you to respond? Do you know the law says that they just have to give you 5 days notice? So if the court can give 5 days notice, we give 10 calendar day notice. And we give the person in good faith, clean hands, the opportunity to ask for more time. Once they don't do that, It's all commerce that makes the arbitration clause applicable in every single case. Go back over the beginning of this video because that's what it explains. Have a good day, have a good night, and don't forget that this information is not being talked about by anybody else, but it's going to be talked about by everybody very soon. Adios.